Lawyers for Payton Gendron were back in court today. They argued a motion that, if granted, could result in another delay in the federal death penalty trial for the admitted top smash shooter.
Channel 2's Dave McKinley was there in the courtroom today. He has the latest details from our newsroom at this hour. Hello, David.
Hi, Scott and Mary Ellis. While making no definitive ruling, the judge in this case, while expressing an understanding for the desire by the defense to put together the best team of lawyers possible, also indicated he was not about to create delays in the trial based on the availability of one lawyer, and remarked that Gendron's lawyers have thus far failed to convince him otherwise. In court, these members of Gendron's defense team described themselves as being a three-legged table, and that the fourth leg they need is in the form of Terry Duncan, one of only a handful of federal public defenders who specialize in death penalty cases. The problem, they say, is that Duncan won't be able to come to Buffalo until late May 2026 after she finishes a trial in California. That's when jury selection is set to begin for Gendron's case. Beyond suggesting that Gendron's defense team seek another qualified lawyer to join them, prosecutors noted jury selection will likely involve weeks of potential jurors merely filling out questionnaires, and argue that Duncan need not be present for that. But Gendron's lawyers insist she does in order to be fully immersed in the case before the first witness is called. They describe Duncan as not just an extra lawyer, but one with federal capital experience, adding, "We're not just down a lawyer, we're down a learned counsel." In the meantime, the defense has also moved to quash as evidence information gleaned from Gendron's Facebook, Snapchat, and Google accounts, all of which they say were illegally seized through a warrant that was overly broad and yielded no fact-based assertions tying them to the shootings. For similar reasons, they also seek to dismiss information from his Broome Community College email account and the search of his laptop and iPhone, which they say was not only beyond what the scope of the warrant permitted, but were rifled through in violation of Gendron's Fourth Amendment protection against unreasonable searches and seizures. They're also looking to have tossed any statements made by Gendron to police following his apprehension, which they say were involuntary, taken without him being Mirandized, and in violation of his right to counsel. Whatever they found in his social media accounts, electronic devices, and what he may have told police remains a mystery, though, as most everything referring to that was blacked out in court filings. Prosecutors also noted that as things currently stand, Gendron's trial isn't set to start until after more than 4 years after the mass shooting, and insist that the 514 families have already waited too long for justice. On your side of the newsroom, Dave McKinley, Channel 2 News.
Thanks, Dave. Meanwhile, two men who were dismissed as defendants in the civil suit involving Payton Gendron have now had the complaints filed against them restored. The Appellate Division of State Supreme Court has reversed a ruling handed down by an Erie County court judge who dismissed the complaints against the CEO of the company that made the body armor Gendron wore that day and the salesman who sold it to him. This means that both men are now officially back as defendants in the civil lawsuit involving Gendron.